Okay, we're going to call cause number 22-39128, the state of Texas versus Marcus Garvey Morris the Jr. Is that right?
Yes, sir.
And we're here with your attorney, Mr. Galmore, and the state's attorney.
Today in the courtroom, two cases are being shown, and both have secrets that will shock you. The first person was given a second chance in life, but he destroyed himself with his own actions. And the second case tells a terrifying story of kidnapping, torture, and ransom. Even the judge said, "I have never seen a case like this in 20 years. What really happened to these two? Watch till the end, because the truth is more frightening than you think."
Okay, we've got an issue right off the bat. There are two motions to revoke unadjudicated probation, and one of them, the newer one, is a first amended, but it's not written that way. I see an older MTRP in August of 24. Then now a motion to revoke probation, which has a first amended number 2 and 3 allegations. So this must be a first amended motion.
That's correct.
You want? Can we,
Move the title to first amended.
any objection?
No objection.
This is corrected on this date, April 6, 2026, without objection. All right. Does the defendant waive a formal reading of this first amended motion to revoke unadjudicated probation filed August 18th of last year? Can we proceed in summary?
He does, and we may.
All right, raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. In summary, this motion first amended motion to revoke unadjudicated probation states that on November 8th of 2022 in this court, you were placed on 10 years deferred or unadjudicated probation for aggravated robbery. Is that true, sir?
Yes, sir.
One states you failed to report to the Jefferson County Probation Office as required on or about September 18th, October 9th, November 13th, 2023, in violation of condition 4 of your probation order, which states you must report regularly. Is that allegation true or untrue?
True.
Are you pleading true to this voluntarily and because it is true as it is alleged? It's yes or no?
Yes, sir.
You understand that voluntarily and knowingly made plea of true to one or more violations, that's enough of probation. That is enough to grant a motion to revoke probation. Your probation can be revoked
Yes, sir.
and you can be sentenced. This is a first degree felony, no less than 5 nor more than 99 years confinement or life imprisonment. Knowing that, do you insist on pleading true?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true in this allegation on this motion to revoke probation. Is that a 5 or a 6?
5.
Yeah, that looks like a 5. It looks like a 6. Look at it.
It's supposed to be 5.
Okay, I'm going to redo that. Okay. All right, an agreement's been reached where you'll be pleading true. Your probation would be revoked. You would be sentenced to 5 years in prison. In this case, is that your understanding of the agreement?
Yes, sir.
If I follow this, and 2 other new cases would be dismissed.
So they're actually older cases, Judge. They were before the probation. So
All this,
that has some Orange County stuff in it that
he was put on probation in November of 22. This was filed in August of 23, this indictment.
yes, sir. But the offenses
Were before, in October 28. Yeah. Anyway, these were cases that were filed after you were put on probation.
yes, sir.
Those are going to be dismissed.
Yes, sir.
Okay. That's your understanding of the plan.
Yes, sir.
All right. And if I follow this agreement, you have no right of appeal of your case. Do you understand?
Correct. Yes, sir.
Okay. I'm going to show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence
Without objection.
without objection admitted. Among other things, this states that you understand fully if I follow this agreement, which I'm going to do, you have no right of appeal of your case.
Yes, sir.
All right. Anything further to add?
No, you're right.
Then if nothing further, I'm going to find that, Mr. Morris, you have pleaded true to allegation 1 of this first amended motion to revoke unadjudicated probation filed August 18th, 2025, which among other things alleged that you failed to report to the Jefferson County Probation Office on or about September 18th, October 9th, and November 13th of 2023. I get the sense here you were an absconder. You absconded, right? You quit reporting, is that right?
Yes, sir.
And did he ever report again? And when was the defendant arrested ultimately?
Um,
A year ago.
Oh, so he had absconded for years. This was September of 23, so 24, 25.
he was taken into custody by Vider PD in July of 2025.
Okay, almost 2 years. The one thing you have to do is report. If you don't report, you're not really on probation, on supervision. That's the most important thing.
Yes.
You failed on that one. Fine. That you have pleaded true to this voluntarily, knowingly, intelligently. That is enough to grant this motion to revoke probation. Your probation is hereby revoked by preponderance of the evidence or greater. Earlier in this case, when you pleaded guilty to the first degree felony of aggravated robbery voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea at that time from State's Exhibit 1 admitted at your guilty plea hearing to find you guilty beyond a reasonable doubt. We instead deferred any finding of guilt and placed you on deferred or unadjudicated probation. Now that your unadjudicated probation has hereby been revoked based upon the findings in this first amended motion to revoke unadjudicated probation, this court goes back to your original plea hearing and finds that there is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt of the underlying aggravated robbery. I now find you guilty beyond a reasonable doubt of that first degree felony. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. The judgment shall reflect that a deadly weapon, namely a firearm, was used in in the commission of this offense. Anything else?
No, yeah,
There are 2 cases
I've got those dismissals.
are to be dismissed, correct? And I will dismiss those.
Mike, can you pick me up discovery?
Fine.
It's a interpret.
Ah,
I've just looked at the probable cause affidavit, which is one of the more disturbing probable cause affidavits this court has had to review in 20 years as a judge. Are y'all ready for a hearing on this? The state ready to go?
Yes, sir.
Because I've more than just casually interested here on, there is video evidence showing the victim appearing in video messages, injured, asking and begging individuals for money, stating she had been kidnapped. Responded, let's see. They found that the defendant and others, the victim had severe injuries, transferred, due to the severity of the injury, she was transported to Houston for special treatment. Suspects tied her up, beat her with a firearm throughout the day, forced her to record and send video messages to her family and friends demanding money, threatening to kill her if payment was not made. A search of the associated apartment revealed evidence consistent with the victim's account, including items indicative of restraint and assault.
right.
Suspects were transported to the Beaumont Police Department. They were interviewed by detectives. Following their interviews, suspects were transported and booked in the Jefferson County town. Were there confessions made by anybody?
Not that I'm aware of, Judge.
All right, go ahead, state. What is the $500,000?
We're asking the court to consider 100,000, Judge. I don't think she has much, if any, criminal record. I'm the second or third attorney that was appointed to her.
Why? What's going on? Are they appointed attorneys?
I believe there's first court appearance sometime in July.
Well, trial, July.
Yeah,
Set for trial.
we'll be ready for it, Judge, if called.
Okay.
But we would ask.
I would like the state to be ready on
Yes,
this
sir.
one.
Yes, sir.
We'll make that one specially said. Go ahead.
We asked the court to consider, she has ties to the community. She has family, she has a place to stay if GPS and home monitoring or home confinement. Family wise, kids, and how old are they?
8-year-old and older.
And who's taking care of the child now?
I'll have there.
And she needs help, does she not?
Yes, sir.
I see a probable cause affidavit. Is there anything the state wishes to introduce to help the court on the circumstances of this case? I see a probable cause, which is, like I say, a most disturbing
Yes, sir.
rendition.
And that pretty much summarizes, other than the injuries, which Judge, since this was set this morning on the announcement docket, I don't show a motion that I had for a bond hearing, but that's okay. We'd stand by, the co-defendants are all set at 500,000. We think this is a fair bond due to the circumstances. We don't get kidnappings for ransom where they're demanding money. It's like very rare in this county. I don't know that I've actually defended one or prosecuted one. And since I've been here in '89, the way they were transporting her around and trying to hide her and trying to get money from people, I would ask the court to keep the bond at 500,000. The only reason I'm not saying raise it is because I didn't file a motion to raise it, because I don't know that any bond is sufficient for what she did. As far as having children, she had an 8-year-old, so she had a child when she was doing this. It's not like she didn't know she had a child to take care of and needed to do some parenting at home instead of running around with this group.
Anything else to add? The court's looking at the four corners of this. I'd like to, the court is interested in seeing some more tangible evidence to support what's in this probable cause affidavit, because it's a most serious thing. In fact, I don't think 500,000 may be enough in what I'm reading. I mean, this is a most disturbing set of facts in this probable cause, but I'd like to see something other than the four corners of the probable cause affidavit. Can we have a hearing on Wednesday?
In the end, Judge John Stevens doesn't rush to a final decision. Instead, he orders a special hearing, demanding more evidence before making a call that could impact lives forever. It's a reminder that in cases this serious, every detail matters. And sometimes, the truth is even more shocking than the charges themselves. Now the question is, should the bond be reduced, or should it be even higher? Let me know what you think.